Assalamualaikum. My name is Nurul Aini binti Muhammad Nurjulani and my matrix number is 288329. So the summary of the background fact of the case given, I can conclude that under Order 14 of the Rules of Court 2012, the plaintiff has filed an application for the summary judgment against the defendants and was granted it. Regarding a loan facility that the plaintiff gave to the borrower and that was in default, the complaint is based on the defendant guarantee. First, there was a term loan facility with a maximum amount of 75 million. And secondly, there was a credit facility with a three various type with a maximum amount of 55.48 million. And for the loan facility, Ibu Kota Ductile Iron Pipe Industry Sedan Berhad, which is the borrower, was granted two loan facility by the plaintiff. First term loan facility up to 75 million partially financed designated machinery and equipment for the project of the borrower. And for the second credit facility, three various with an upper limit amount of 55.48 million each. Under security document, for the first facility, extensive list of the security document execute including letter of offer change, term loan facility agreement, debenture, assignment of a various document including performance bonds, license, permit, insurance, contract proceed, sales and purchase agreement, and the last one is letter of change. For the second facility, another extensive list of the security documents including letter of offer change, facility agreement, debenture including a second fees and the loan and the floating charge, deed of assignment, supplemental deed of assignment including a project length and payment, supplemental facility agreement, second supplemental facility agreement, and also letter of change. Under key terms of the facility, the interest calculated based on the plaintiff effective cost of fund plus with the additional percentage which is varying for each facility. And the interest was subject to capitalization and monthly payment. Both facilities were protected by the significant paperwork which include the assurance from the defendants and assets transfer.
Assalamualaikum Doctor, my name is Anis Najwa binti Mirosli, matric number 284592. I will explain the issue raised by the defendant. For the first issue, for P declaration explanation, the 10 March 2017 notice of demand and 16 May 2017 notice of termination was sent to the borrower, not the defendant. P notice of demand and notice of termination does not need the principles, methods of calculation and the e-curve rate as claimed by the defendants. The law and security documents disprove this allegation. For the second issue, P declaration, the first facility and the second facility were terminated on 16 May 2017. So no additional notification about the change to the e-curve rate were sent to the borrower after the P notice dated 2nd September 2016 regarding the rate modification. For the third issue, P declaration explained concluded from the condition of the first facility and the second facility that have been agreed upon between P and the defendant that first, the guarantees provided by the defendants are additional security to P and should not be impaired by the creation of other securities. Second, the plaintiff is not obliged to exhaust all its remedies under other securities before it can enforce the guarantees provided by the defendants. Lastly, for the fourth issue, P declaration explained, proof from the affidavit state that the receiver and manager assigned by P to oversee the borrower are presently active and are making an attempt to sell the land and building and the plant and machinery on the project site altogether. This does not stop P from suing both defendants.
Does the plaintiff have the right to enforce the guarantee provided by defendants due to the loan facility being in default? The plaintiff has the right to enforce the defendant's guarantee due to the loan facility's default. The court determined there is no viable defense against the claim based on guarantee documents, granting summary judgment. The defendant's guarantee agreements details the terms and circumstances for enforceable guarantees, including guarantor's liability as a major debtor and the plaintiff's freedom to change the facility. The guarantee documents, such as a bank-approved statement of account or certificate of indebtedness, are legally binding proof against the guarantors, indicating that the defendants offered a guarantee that can be enforced if the loan facility is defaulted. In summary, the plaintiff has the legal right to enforce the guarantee provided by the defendants due to the loan facility's default, and the court found no valid defense against the claim.
The central issue from the plaintiff that failed to apply the defendant of change in rate, prompting an exploration of whether such notification was contractual mandate. The contractual term will be pivotal in the responsibility of each party and determining if the proper oversight qualifies as a breach of contract. The defendants are likely to alteration in rate were of substantial significance, necessitating implicit communication from the plaintiff. If the contract implicitly mandates the plaintiff to inform the defendants about rate change, the defendants may find a robust legal footing. However, in the absence of implicit contractual obligation, the court must dive into implied term, industry norm, and the broader context of the agreement to discern the intention of the party regarding notification of rate adjustment. The defendant's contention that the change occurred without their knowledge and consent introduced element of transparency and fairness into the legal discourse. The plaintiff, being a financial institution, altering rates without sufficient notice or consent could be perceived as a breach of the duty of good faith. The defendant may find legal ground for recourse based on the plaintiff's failure to fulfill this obligation. In addition to contractual and regulatory dimension, the court is likely to evaluate the practical impact of the rate change on the defendant. If the alteration inflicts substantial adverse effect on the financial standing or contractual performance of the defendants, it could booster their case for seeking damage. Economic loss arising from the plaintiff action constitute a pertinent factor in determining the scope of the defendant's right to pursue legal action. Lastly, the defendant possesses the right to sue the plaintiff hinges on a nuanced analysis of specific facts, contractual provision, relevant laws, and the broader legal principle governing contractual relationship. The conduct of each party, the nature of the change in rate, and the overall fairness of the dealing emerge as a pivotal factor for the court contemplation.
Assalamualaikum and hi doctor. I am Siti Rodamiti Abdul Razak and my metric number is 284591. I will explain type of guarantees for dependent 1 and dependent 2 and their liability as principal debtors. Dependent 1 and Dependent 2 provided corporate guarantees for the loan facilities extended by Bank Pembangunan Malaysia Berhad (BPMB) to Ibu Kota Realty Sdn Bhd. The corporate guarantee were in the form of separate documents executed by each defendant. Dependent 1 and 2's corporate guarantees specified that they were directly responsible for the repayment of the loan facilities and their liability would not be affected by any extension, renewal, alteration, or variation of the loan facilities or any other arrangement made between the borrower and BPMB with or without their consent or knowledge. The corporate guarantees also specified that they were in addition to and not in substitution of any other rights or securities which BPMB may have under or by virtue of the term of the loan facility agreement or any other guarantee or security. The guarantees could be enforced without first having resource of any other securities or right and or without taking any other steps or proceedings against the borrower or any other surety, guarantor, indemnifier, or person. Furthermore, the corporate guarantee stated that a statement of account in writing or certificate of indebtedness duly certified by any of other authorized officer of BPMB showing the indebtedness of the borrower or any judgment recovered by BPMB against the borrower in respect of such indebtedness shall, save for manifest error, be binding and conclusive evidence against the guarantors. Therefore, in their role as primary debtors for the loan facilities that BPMB gave to the client, Dependent 1 and Dependent 2 provided corporate guarantees.
Beyond the borrower's default, the liability included direct responsibility for the repayment of the loan facilities. Any changes, variation, or extension to the loan facilities, as well as any other deals between the client and BWBB, whether done with or without their knowledge or consent, would not affect the corporate guarantee's ability. That's all from me. Thank you.